Can I be personally liable for an estate, trust, or conservatee's taxes? What is the federal insolvency statute? Where the delinquent taxpayer is insolvent but has not filed a petition in bankruptcy, the IRS's prior right to payment is established by the federal insolvency statute, 31 U.S.C. section 3713A. That statute states in relevant part A1, a claim of the United States government shall be paid first when a person is indebted to the government and is insolvent, and 1. The debtor, without enough property to pay all debts, makes a voluntary assignment of property. 2. Property of the debtor, is, if absent, is attached, or 3. An act of bankruptcy is committed. The statute is rooted in English common law and embodies the philosophy that the king's debtor is dying, the king shall first be paid. Magna Carta, 1225. See also United States v. Moore, 1975. United States v. Bank of North Carolina, 1932. The statute is liberally construed to effect the purpose of securing adequate revenue to the United States Treasury. Can an executor, conservator, or trustee of a trust or estate that owes taxes be personally liable? In certain circumstances, yes. Under subsection B, the federal insolvency statute, a representative of a person or an estate, except a trustee acting under Title 11, paying any part of a debt of the person or estate before paying a claim of the government is liable to the extent of the payment for unpaid claims of the government. 31 U.S.C. sections 3713B. Thus, an executor, conservator, or trustee whose estate or trust is insolvent and who, after an act of bankruptcy, does not pay a priority claim of the IRS first will be personally liable. The federal insolvency statute is applicable in tax cases. It is settled that taxes are claims of the United States. Also, an estate or trust is insolvent as required by Part A when it owes more than it has in assets. Insolvent has long been understood to mean insolvent in the bankruptcy sense, which is when the debtor does not have enough property to pay all debts. United States v. Oklahoma, 1923. When the total of the tax debt plus other debts exceeds the property of a trust or estate, it is insolvent. Placing assets in the control of the probate court in a conservatorship over an estate and disrupting assets to the conservatee and to creditors satisfies the act of bankruptcy requirement under subpart 3. But the IRS is not always first. Under 26 U.S.C. section 6323A, the exception to the federal insolvency statute exists when a judgment creditor has a perfected lien recorded before the federal tax lien is recorded, when a trustee, conservator, or executor of an estate is concerned with their own liability due to potential decisions to pay those other than the IRS, an interpleader action is often considered. Interpleader actions are authorized by 28 U.S.C. section 1335 and Rule 22 of the Federal Rules of Civil Procedure, where persons holding funds to property upon which conflicting claims are being made by others may deposit the funds with the district court and require the other parties to litigate their interests. Libby versus City National Bank. Because the risk of handling these issues wrong can be high, it is important to consult with or retain experienced counsel. Daniel W. Layton, the author of this post, is a former IRS trial attorney and former federal prosecutor who is tasked with handling criminal tax prosecutions and civil litigation, including tax refund suits, lien enforcement, and foreclosures. As a tax attorney in private practice in Newport Beach, he uses his knowledge of IRS procedures and rules to keep the IRS in check and protect his clients' rights. He may be contacted at 949-301-9829. Voice assistance provided by legal assistant Benjamin Tu.